Hi everyone, my name is Stephen Reagan and I want to welcome you all to the 5th edition of these sound bites where I talk about some current events in privacy and data protection. My name is Stephen Reagan. I'm the Principal Privacy Consultant and SME at Rangu on privacy and data protection. So today I'm going to talk about two things. The first being this kind of controversy or this conflict that's arising between some really big technology companies, in particular Apple and Facebook. And really, this is related to Apple's release of their iOS 14.5 software update. And this will require apps to get opt-in or consent for tracking. And then the second thing I'm going to talk about today is the European Data Protection Board's opinion on the European Commission's draft adequacy decision for the UK. So in February of 2021, the European Commission released their draft on saying the UK was adequate for data protection. The laws in the UK provided essential equivalence with that of the GDPR, and therefore data transfers could continue without any additional safeguards between Europe and the UK. So I'm going to dive into the details of those two things today. All right, so this showdown between Apple and Facebook. So Apple is releasing its iOS 14.5 software update. What this will require is for applications to track and collect your data, these apps will have to get the user opt-in in order to do that. So I'm actually going to show you something on my cell phone that you can do if you don't want to see these pop-ups for ad tracking. You can actually just go to Settings, go down to Privacy down here at the bottom, click on that, go to Tracking, and allow apps to request to track. You can just turn that off and then you won't get the pop-up, and these applications will not track you and collect your user information. And so this is a really interesting initiative. Apple is really taking the stance that they will protect user privacy and really encapsulating this idea of privacy by default in the GDPR. So how does this tracking work on apps? This is part of an initiative by Apple called the App Tracking Transparency. And how it works is that we all have unique identifiers called IDFAs for the purpose of tracking in apps. So for example, you download a meditation app. Okay, you have a unique ID. This meditation app wants to then target you for advertisements for a yearly subscription. The app will go to Facebook, say we want to target this user, and here's their IDFA. If Facebook has a user that matches that, then they can target these advertisements directly to them. So to do this, the app would take this user ID, as I've just mentioned. So with Apple's update, the app along with Facebook, along with this meditation app in this example, will have to get that user opt-in to track individuals. Now, if you've taken the step that I've just demonstrated on my cell phone, you won't get this pop-up asking you this question. You will just be automatically opted out of that. This initiative by Apple is really relevant and really interesting because it's likely that most people will likely not opt in, and this will make ad targeting a lot more difficult, and it will really limit applications and organizations from creating these user profiles in which to target individuals for advertising. And this conflict that's arisen between Apple and Facebook is really kind of symbolic of this greater conflict between the two organizations that is developing, and will be really interesting to see how it plays out. In particular, both organizations, Apple and Facebook, are both developing their own Facebook. In the case of Facebook, virtual reality, and in the case of Apple, augmented reality. So there are just conflicts that go even beyond this IDFA, this app tracking transparency, and this Apple's initiative and perspective on privacy, and it really goes to other aspects of these organizations' business strategies. So it will definitely be interesting to see how it plays out. Mark Zuckerberg and Facebook have really taken a stance of kind of dominating their industry and buying out any competitors. But Apple is really big. It's not a small organization by any stretch of the imagination, and they definitely have the resources to combat Facebook. So, yeah, let's see how it plays out. Now turning to the European Data Protection Board's opinion on the European Commission's draft adequacy decision for the UK. So the opinion from the EDPB was in response to the European Commission's endorsing a draft implementing decision that came out on February 19th, 2021. In this process of determining adequacy, the European Commission now asks for the opinion of the European Data Protection Board, who adopted on April 13th, 2021, an order, their own opinion. And they analyzed the UK data protection framework, in particular looking at the UK GDPR, the Data Protection Act of 2018, and the Investigatory Powers Act of 2016. This is all in response to the UK's leaving the European Union. So prior to Brexit, the UK was a member of the European Union, and thus data could flow freely between Europe, between the continent and the UK. With the UK's exit from Europe, this means that an adequacy decision had to be negotiated. Otherwise, additional safeguards would have to be implemented on data transfers from Europe to the UK. And so this issue was so complicated that during the transition period of the year 2020, no agreement could be reached. And for this reason, the bridge period was negotiated and set to expire on June 30th, 2021. And so there's kind of this expectation now that the European Commission will give the UK an adequacy decision, which means that data will be able to continue to flow again freely between the European Union and the UK. And this really begets an analysis of whether or not the UK laws are essentially equivalent to Europe and the GDPR. The UK has, again, their own version of the GDPR. It basically mirrors what is in Europe. And so by all, on its surface, it seems apparent that the UK laws would be equivalent to those in Europe. However, the European Data Protection Board identifies some challenges presented by the UK data protection and privacy system. And they really noted 5. And I'll go a little bit in depth into these. But I will just state them really quickly, really succinctly, to just keep them in mind. So the first challenge presented is the evolution again of this UK legal system. Now that the UK is no longer beholden to European laws and including European case law from the Court of Justice of the European Union, the UK legal system can now develop their own data protection and data privacy regime, including giving their own adequacy decisions. And so the EDPB really notes favorably that this adequacy decision will be restricted to 4 years and will be reviewed at the end of that 4-year period. The second challenge presented by the UK data protection system is this immigration exemption. The third issue is, again, onward transfers of data, so data going from Europe to the UK and then from there going to other third countries. The fourth challenge presented by the UK system is the access by public authorities to data transfer to the UK, in particular for national security and surveillance purposes. And then the fifth challenge was procedural and enforcement mechanisms, where the EDPB looked at the role of the Information Commissioner's Office, as well as independent supervisory authorities on issues of privacy and data protection. So from the outset, the EDPB noted with approval that the UK is a party to Convention 108 and 108 Plus, which the Council of Europe Treaty protects the right to privacy of individuals, really taking into account the increasing data flows across national boundaries. So getting a little more in depth into the challenges presented by the UK that were noted by the European Data Protection Board. Again, the first one is the evolution of the UK legal system. Again, the EDPB noted that the UK government has indicated its intention to develop separate independent policies on data protection. So again, this really creates a question of how the UK laws in this area will develop, especially as the UK government has indicated it wants to be a leader in data, in technology, and in, for example, artificial intelligence. So that second challenge presented by the UK's data protection and privacy system is really this immigration exemption. And the EDPB requested that the European Commissioner provide further info on this exemption, which really lays out under Schedule 2 of the Data Protection Act that controllers involved in immigration control do not have to apply certain data subject rights. In particular, those apply to the right to be informed, the right of access, the right to deletion of data, and the right to restrict processing of data. And this is really framed by the UK as something necessary to to protect their sovereign borders. And this is an issue of national security, and thus they can deviate in dealing with what they call a national security challenge, again in this context of immigration. And so the European Data Protection Board wants to ensure that the laws are necessary and proportional, and that the disregard of these fundamental rights to privacy are restrained and are restricted. The third challenge that the EDPB identifies is, again, this issue of onward transfers. And there's really this concern, and now I'm quoting, that onward transfers might undermine the level of protection of personal data transferred from the European Economic Area. And really, again, concerns that data will be transferred from Europe to the UK and then will be transferred onward to third countries that won't exhibit essential equivalence with the laws of Europe. And in particular, the EDPB notes the UK-US Cloud Act Agreement, and the EDPB requests that the European Commissioner continue to monitor this agreement as well as the EU-US Umbrella Agreement. And these are agreements for data transfers, for trying to solve national security challenges, as well as prosecute criminal investigations. So on this note of government surveillance and national security, the fourth challenge noted by the EDPB is this access by public authorities to data transferred to the UK. Again, in particular, noting the necessity and proportionality of these national security programs and law enforcement purposes. The EDPB welcomes the Investigatory Powers Tribunal that can hear cases on the use of the Investigatory Powers Act, as well as and so the EDPB notes that the IPC is an independent judicial commissioner with independent judges who can rule on issues of national security or issues related to the investigation and surveillance of individuals, and can rule on these issues. And so that's really, and can also provide redress to individuals, which has presented a really big challenge in the case of the U.S. and the essential inadequacy of the U.S. Government surveillance apparatus. And on that note of these procedural and enforcement mechanisms, again, the EDPB analyzed the following aspects of the UK data protection framework as covered under the draft decision, noting the existence and effective functioning of an independent supervisory authority, again noting how much money the ICO has received and how they have prosecuted cases in the areas of data protection and privacy. And the EDPB really just wants to have the European Commission focus on really how things will develop in the UK, really note how developments are ongoing there, particularly as they diverge from what's happening in Europe, and how they might further diverge as the UK and the EU grow and separate. Yeah, that has been the two topics I really wanted to touch on today. Again, that conflict between Apple and Facebook, and that release of the iOS 14.5 software, and we'll see how that shakes up ad tech and the collection of data from applications. And then again, the EDPB opinion on the European Commission's draft adequacy decision for the UK. So until next time, have a good week, have a good day, have a good life, and I'll see you here next time.